which is not that easy to understand because this project involves, as I have explained, not only financial issues, but also legal issues, and most importantly, financing issues. There's a difference between financial issue and financing issue. When we talk about financing, we mean borrowing money to do something. Okay, for a M&A project of this huge size as the Twitter project, financing is the most critical issues to be resolved beforehand by the buyer. In this case, of course, is Elon Musk. Okay, he will need to first resolve all the financing issues, which means he will need to have enough money to be able to buy the shares, okay, as he has planned. However, to get enough financing, he will need the assistance from all the banks, institutions, and venture capital, sovereign funds to make the money available for his use by or through a loan or some other means, so that he will have enough money to buy the shares to finalize the deal, which is not an easy thing to do. And after he has done or resolved his financial issues, the next thing will be the legal issues to resolve, which consists of not only contract review, contract negotiation, and so forth, and also another thing that I have to tell you in advance is the due diligence process. Okay, due diligence process is the most, I would say, most critical legal issues to be resolved by any potential buyer of another company, because he will have to know whether this company is a good company. This company keeps all the things that he needs for which he decides to purchase the company. Okay, if the company is not good enough, he will not be able to know the real situation unless he's done a thorough due diligence to come up with a report from the lawyers engaged in the due diligence job, so that he will understand, so that he can even report to the company shareholder saying that, hey, this is good company I need to buy, and for that purpose I have hired this law firm to do the due diligence effort, and the result that they have come is that this is a feasible company, and based on which it is a feasible deal that we can engage. So we're talking about contracts, we're talking about due diligence job, and this is legal work, financing work, and also the financial work. How is it that you can do to make sure the deal will go through to make a profit, for example, in 3 years from now, 5 years from now, which is a director's or a management team's responsibility towards the entire shareholders, so that it's your job to come up with the best deal you can come up with, so that you can report to the shareholder saying that this is a good deal. Not only it is safe legally, but it is also sound financially, based on the suggestion and advices from our law firm, as well as our financial advisors such as Morgan Stanley. Okay, so some of the other what we call investment bankers that you are familiar with. Okay, so we have resolved the financing issues, we have resolved legal issues, we have also resolved the financial issues, so that we can go ahead to proceed with the closing of the deal if everything goes well. That's the general picture. Okay, so let's see what he has to say. This was done in September. Okay, so at that time it was all a mess. Okay, everybody was shouting about that we're not going to be able to do it because Elon Musk has revoked his offer he has terminated his offer, so on and so forth. It's not likely that we're going to see the deal through. However, in October, everything is done. They have gone through the closing. They have finalized the deal, and Elon Musk became the new CEO of Twitter in October. Okay, in October. So in terms of the speech delivered in September, they didn't know what would have happened. Okay, later on in October. Train wreck, 火车 train wreck, train collision. At the time, it was a mess. So nobody really knew what would have happened, knowing that people are suing each other in San Francisco, also in Delaware. Okay, different lawsuits have been brought related to the transaction in question. So in September, this speaker will say that, hey, this is a difficult situation. We don't know what's going to happen, whether the buyer and sellers of the transaction will go through with the deal. They don't know. The only thing that they could see at that moment in September was problems. So there were problems to deal with in September, but they didn't know. I mean, all the problems had been solved very quickly, only in 2 or 3 weeks. Okay, that's good. Expert witness. Expert witness is a witness with certain type of expertise that can testify in the court in front of the jury to have his or her opinions on the expertise that he has been called for to address. That's what this expert witness is for. It is very expensive to hire a expert witness. Okay, it's not cheap. It may take you $1,000 US an hour to hire an expert witness to say something good about your case in accordance with his or her expertise, depending on the focus of the testimony will be. However, you have to know that this is an expert witness that is not going to be as neutral as you think, because after all, he's paid by one of the litigants to the litigation, either by plaintiff or defendant. 也就是说，像这种专家的证人，他不是像我们一般认为你是专家，你应该是很公正的嘛。但事实上不是，在诉讼里面只有输赢。There's only win or lose in any litigation. Okay, either side will try their best. Okay, actually, both sides are trying their best to win the case by or through the hiring of an expert witness to say good things about their customer, depending on whether it is plaintiff or defendant that they represent. Okay. He had been hired as an expert witness in another litigation, which is perhaps related to the Twitter litigation being brought against Elon Musk. Okay, perhaps, I don't know, 2019. In 2018, it was another case brought by the Tesla shareholders suing Tesla directors, okay, for failing to enforce or to failing to perform their fiduciary duties towards the shareholders. 也就是说，在公司法里面，股东是可以告董事的。Okay, 因为 directors have been appointed to perform a good job for the benefit of the shareholders as a whole. If for one reason or another, any directors is not performing his job, shareholders can sue him or her for a breach of his or her fiduciary duty towards the shareholder. And in that case, that was the case was about when the guy was saying that a 2018 Tesla case, which was brought in San Francisco. Oh, why the lawsuit, why in the U.S. a lawsuit can be brought in California and another lawsuit can be brought in Delaware? 我的问题就是说，你在美国为什么有些诉讼会在加州被提起，有些诉讼会在像这个 Twitter 的 case 在 Delaware 被告？其实很简单 ，It's not that difficult. It all depends on where the defendant resides. 以原就被。In the California case lawsuit, the case was brought in San Francisco, California, because I believe Tesla was registered in San Francisco, California, so that the plaintiff, those shareholders, when they want to bring lawsuit against those directors, the proper place that they should bring to sue Tesla is San Francisco court in California. Okay, because it's about federal law. If it is federal law, it should be brought in the federal court in San Francisco. OK， 这讲中文就是说，美国的诉讼制度分两种 ，federal level and state level. OK， state level and federal level. Basically, simply put, you go to federal court to sue for things involving federal law. If it is federal law, you go to federal court. And if it's not about federal law, it's about state law. Okay, I don't know. They're just state laws in terms of quantities is a lot more than federal law. Okay, most of the things that you see yourself in involve state law, and because of that, you go to a state court, California state court, New York state court, Delaware state court. But if it is a federal law, in this case, it is about U.S. Securities Act, 就是美国的证交法. That's federal law. Okay, if you are not happy with what if you're thinking that your directors is ignoring, okay, their fiduciary duties in violation of the Securities Act of the United States, you go to federal court. However, if it's about damage, because fulfilling some sort of duties, okay, to your damage. 假如果说你是说，因为你不是跟证交法有关的，基于其他的原因，这些董事不好好干活，让你身为股东遭到损失的时候 ，it is state law， 对不起 ，state law claim， 那是一个州法上的诉讼。所以 as I was trying to explain the situation where when you see a situation where you need to bring a lawsuit, okay, in the United States, first you have to decide what kind of a law based on which I want to bring my lawsuit. If it's federal law, I should go to federal court. However, if it's about, hey, this guy has driven his car carelessly, okay, to cause me danger, to cause me damage, okay, by colliding into my car, it's a state claim. And you should go to the state court. So it's complex. However, it's not as complex as it seems because a judge, a court can always consolidate. So that if this cause of action, 就是我们讲诉有, is based on both federal law and the state law, and it is the federal court that this lawsuit has been brought, the federal judge presiding over this case has the power to consolidate both cause of actions, then to deal with both the federal law and the state law in the same case. Okay, so it's complicated. I just want you to understand, to a certain degree, some of the U.S. litigation system, I think you should know, okay, to be able to understand this case. In this case, there are different reasons, different cause of actions, based on different laws. for which the lawsuits have been brought here and there. It's not just San Francisco. It's not just Delaware. There's somewhere else. If you go see the you will go on Google to take a look what has happened. You will know actually there's plenty of lawsuits have been brought. Okay, over not only the Twitter case but also some other cases which have, to a certain degree, have certain degree of connection. For the first two bullet points, actually, if I don't know, but I need to do some more research, because he was talking about the failed Tesla MBO. That's a management buyout project. But in this case, it's the Twitter MBO. So I don't know the connections between the two cases. Maybe he said it wrong or by mistake, but I'm not so sure. But if we were talking about Tesla, and because in the Twitter case that we will be talking about, and he will be talking about in a little while, is the fact that it was Twitter that actually it's the Twitter shareholders are selling their shares to Elon Musk. They're not selling shares to Tesla. So in this case, in the Twitter case, it is the case between Twitter shareholders as the sellers and Elon Musk through his what we call representatives. Three companies completely owned by Elon Musk to serve as the buyer of the shares, which has nothing to do. I mean, which is only remotely related to Tesla as a company and Tesla shares. Okay, so let's find out. But at this moment, I'm a little confused about what he says. So up until now, it was all about Tesla. Okay, he was saying basically, hey, I want to buy Tesla shares from Tesla shareholders, and to do that, I'm all prepared for my financing, meaning that I have come up with enough money to buy enough Tesla shares. And according to this guy, he says that the statement was totally, what should I say? It was totally untrue. Okay, and the statement was a lie, okay, because he didn't even have enough money to buy the Tesla shares that was mentioned in this particular statement. So that part of the deal had been dropped long in 2018. So that was about the Tesla MBO, which is distinct from the Twitter MBO that we're about to talk about, starting from April 1st, 2022.
The Tesla shareholders won summary judgment, hard to do.
Okay,
but they
just a second. Summary judgment. Okay, this is if it's difficult for you to comprehend, I can later on explain it in China. Summary judgment. Okay, in the U.S. Okay, you have to know when it comes to litigation, both in federal court and the state court, right to jury is protected. It's guaranteed by the U.S. Constitution. 在美国呢，你有权利按照宪法呢去实施 jury trial. Okay. It's a constitutional right. Nobody can take it away from you. However, in terms of the litigation procedure, there will come a time and point where the presiding judge will decide whether there are any factual issues to be determined by the jury, which will come about, let's say, 6 months from now. 但是你在诉讼进行的过程当中呢，法官要决定，这个案子好清楚了，不需要再由 jury 来决定了，因为已经没有需要让 jury 决定的事实，因为 jury is supposed to be a fact finder. 他们是决定事实的。If there's no issues about facts and the facts are so clear that there's no way that jury will come up any other verdict, okay, based on the same set of facts. 不可能 jury 他会基于相同的事实会得到另外一个的结论。Oh, by the way, the decision made by the judge is called judgment, 对不对 ？As we all know. But the decision made by jury is verdict. Okay, and so 这叫 summary judgment， 我们可以把它简易判决。It is a legal issue to be determined by the judge, not by the jury. And so judge is so powerful at this moment in time during the litigation to say, hey, no more. We have to we have to continue with the litigation by coming up with a jury to do the fact finding because the facts are so clear at this moment. So I can make the judgment right now based on this set of facts being presented at this moment. 所以这是一个法官很强有力的武器。所以你不要以为在美国诉讼里面，因为都是由那个 jury 来决定，好像法官就不重。法官很有力量的哈。For example, being able to come up with a summary judgment saying, hey, plaintiff wins, no more do we need any jury to come up in a little while. 所以很有趣。所以在这个案子里面，在我们讲in 2018 case, the shareholders suing Tesla company won because of summary judgment rendered by the judge saying that, hey, Elon Musk lied about the fact that he had secured enough financing to get the buyout done, which is a lie, and it is so clear. And I know that for a fact, so there's no way that jury could come up with any other verdict that is different from mine. So I'll do the summary judgment, and the shareholders win, directors on Elon Musk lose. That's all there's to it. When if in the future, when you see a statement reckless, okay, it's also a legal term. Reckless disregard. 就是说it's a general idea. When we talk about tort, 侵权行为法 talk about law, okay, 侵权行 everyone, okay, all of us in this society maybe should bear a certain degree as a duty of care. 所以我们最传统的侵权行为法讲说，嘿，每个人在他的行为都有负责任的注意义务，这很简单嘛。You will be held accountable for what you have done, okay? If you've been found negligent, okay, or you have done anything wrong through your intentional misconduct, 就是故意或者过失。To the damage of other people, you have to pay for that damages. 这很简单，这是一般的基本的侵权行为的规则。但是 ，according U.S. common law, 美国的 common law, as I have explained to you, common law is not federal law. Common law is state law. It's tort law. So if you got hit by the driver of another car to your damage, you can sue someone in the state court, according to the state law, saying that because you've been negligent driving your car to my damage by colliding your car into mine, and it is your fault, okay, you've been negligent, then you have to pay for my damage. That's easy to understand. However, I also want you to pay me a kind of punitive damage, okay, 惩罚性的损害赔偿 which only basically, as far as I know, they don't exist in Taiwan. Okay, they don't exist in most of the country because when we talk about civil law, it's about compensation. Okay, 我们讲民法，我们就讲是补偿的啊。So therefore, when you see something, so when you seek remedy based on your civil claim, the award will be compensatory, 是吧？ 就是补偿性的。There's no way that the judge will award a punitive damage. However, in the U.S., in certain state laws, it says that if reckless disregard of other people's safety is found, then a punitive damage can be awarded. 也就是说，你比过失更严重，你完全轻忽别人的权益的时候，法官会说，你除了要付 compensatory damages, you have also need to pay punitive damage because you have been recklessly disregard the rights of the other. For example, drinking a lot of alcohol. 你就讲，你本来只是出车祸，你只要付损害赔偿，但是如果你是酒后驾车，你可能就要付这个 punitive damage。所以 whenever you see a statement or a sentence referring to reckless disregard, you know this is going to be something serious. You know, you have to be careful about it. What is bots? AI robots. Okay. 其实 I strongly recommend you guys to go take a look at movie. And the name of the movie, that was an old movie that when I watched the first time, I just simply didn't understand. And I was not interested at all when I was a college student in 1982. But I think that was the first movie talking about AI, talking about the conflict between robots and humans. Okay, now we have a problem, okay, because there's no easy way for we people as humans to distinguish robots from humans in cyberspace. That's how they call it. And the name of the movie is Blade Runner. You should go take a look at it. I don't know whether there's that movie is still available, but Blade Runner is I think it's the first movie talking about, hey, there's no way you can tell robots from a human by reasonable human efforts. It's extremely hard to be able to tell a robot from a human. In that particular movie, you have to ask hundreds of questions, and you can come up with a conclusion saying, hey, the person that I'm talking to is a robot or a real human being. So if you have the time, take a look at that movie. There's another legal jargon. 他应该知道，他知道或他应该知道。Okay. Knowledge is a very powerful weapon a plaintiff can use to defeat any defendant's defense in a tort case. 就是说，因为在侵权行为法里面，你要证明他故意或者过失嘛，对不对？ But which is a very difficult thing to do. How can you prove in a court in front of the jury to say, hey, this guy was negligent because he dozed off while driving, because he was under the influence of alcohol when he was driving? 你要证明啊，他打瞌睡啦，或者喝酒啊。 It is plaintiff's obligation to prove to the satisfaction of the jury in saying that the guy was negligent. 所以很困难，但是法院律师又会想出很多怪招。Well， 他做这件事 deliberately to hurt somebody. OK， 回到我刚刚讲 ，there's no way you can prove that he knows for sure. 当然there are always ways to prove he has the actual knowledge to take this risk, which has ultimately caused your damage. 也就是说，他知道这个很危险。譬如说，我只是举例子啦，他在人多很多的地方放鞭炮，假设了 ，he has the knowledge, OK， 但是通常你很困难。When it comes to the burden of proof, it's very difficult. Okay, but so the only thing that you can do as a lawyer, okay, advising your client, 你的律师你去建议你的客户的时候，你说 you can't prove he actually knew it when he did it, but you could prove so that the jury could believe that he should have known it. 他应该知道，而不他虽然我没有办法证明他不知道，他知道，但是我们可以证明他 as a college graduate and of 20 years old, he should have known. He could have hurt somebody by igniting a firecracker in the crowd. He should have known, but there's no way I can prove that he actually knew it. Maybe he was an idiot. He simply didn't know, but he should have known as an average person. 我今天讲太多法律，但是我觉得最后一堂课，我觉得你们还是要有一点，就是说关于说what's going on here? What is being discussed or is being disputed here thus far? Go ahead. Okay, just a second. First Amendment 就是美国的第一宪法修正案啊 ，This is very complicated. OK， 我觉得那是一个 semester 的 course to talk about freedom of speech， 言论自由，那是 most interesting class. OK, in any JD program in the U.S. OK, as I was talking to him, I was trying. Let me introduce a little bit about U.S. Okay, legal education system. In the U.S., you don't go to law school after high school. Okay. In Taiwan, you go to Taiwan University legal department after you finish your high school, right? But in U.S., you don't go to law school until you finish college. Okay. First of all, you have to do high school. And you finish high school, and you go to college, you finish college, and you go to law school. So law school is 3 years, okay, about 150 credit courses. Just 3 years, we need to spend a lot of money doing that for 3 years. It's a 3-year program, the JD program. But they teach you everything you should know if you want to be a lawyer. So it's a law school. So the name of the program is JD, Juris Doctor. In that program, constitutional law is the most interesting course that you can take. Okay, because it covers all the issues most people care about. For one thing, freedom of speech. Okay, freedom of religion. It's the way that they teach constitutional law in a JD program is not the same as the Constitution class you take in Taiwan University legal department. Because there are so many cases that you have to read to understand what freedom of speech really means when it's said by some of the justices in the Supreme Court 50 years ago, 100 years ago. So 我就用中文讲，在美国的宪法，它不是宪法读条文。当然，美国宪法有条文，就像我们台湾、我们中华民国现在有条文。但是你 when you go learn Constitution, you learn constitutional law. 所以你在美国读宪法的时候，你是读那些大法官所写的 opinions about freedom of speech, about privacy. I mean, I don't know whether you have seen people talking about Roe versus Wade case. Okay, that case was decided, I don't know, 1970, 1960. Okay, saying basically women has such privacy protected by the U.S. Constitution to decide whether she wants to have an abortion. 就是我们堕胎的权利，就是1960年的 Roe versus Wade. The basis for which the decision was made in 1960 was because the justice at that time said the privacy right is a part of the constitutional right being protected by U.S. Constitution， 那你觉得他是不是胡说？因为美国宪法里面根本那个时候哪有什么 privacy 的观念 ？When it was first made and passed in 1776， 但是美国大法官他就可以编出一套来 ，saying， hey，